meeting room.
Okay.
So the first one will be Vike, V-I-K-E, Karn. So I'll bring her.
Okay.
Okay, here she is.
Hi, are you Karen Veek?
Yes.
Did I say that correctly?
Karen Veek, yes.
Karen Veek. Okay, thank
Yes.
you. All right, Ms. Veek, this is for initial appearances. I'm Judge Matt Rolfe. We're conducting our hearings tonight via Zoom. I'll call the case of City of Stoughton versus Karen Veek. Basically, we're here tonight it's a plea night. There are three plea options. One's guilty. First plea option is guilty. Your next plea option is no contest, or your third option is not guilty. But what I do is I review the citations with you. I just want to make sure that you have there's a factual basis for it. And you understand what's going on. If you have any questions, just let me know that as well. So
Okay.
let me open up the, I'm going to minimize the screen. You'll still be able to see me, but what I usually do is I will then open up the police report so I can take a look get your address right, make sure that I know that as well. Just a minute. Let me X out of everything. We're all kind of learning all these new systems, aren't we? Okay. Ms. Veek, do I have your correct address on Silverado Drive in Stoughton?
Yes.
All right. You received looks like 4 citations. Let me review the lesser ones first. You were cited for possession of open intoxications in a motor vehicle for a driver. This citation carries a penalty of $187. Do you understand what possession of open intoxicants in a motor vehicle for a driver is?
Yes.
Okay. Now the bond amount on this is you're at $100 plus cost. The bond amount is $50 to, I believe, $500. So you're kind of on the low end of the scale. But that means that I can either increase the bond or decrease the bond if I state my reasons.
Okay.
So I understand the fine forfeiture of that as well.
I guess so.
$187. That's usually
Okay.
Yeah, that's usually how much it is. So, and no points issued your driver's license. The next one is operating without required lamps lighted. This citation carries a penalty of $86.20. That's $20 forfeiture plus cost and 3 demerit points issued your driver's license. Do you understand what operating without a required lamps lighted car is?
Yes.
Okay. Your other those two citations. Now, your other citation is for operating motor vehicle while they're under the influence of an intoxicant. Now, this citation carries a penalty of between $150 and $300. However, they add a $355 assessment charge. Now, when I say that these are $20 plus cost, $50 plus cost, the initial bond, the initial forfeiture is $50, but what happens is the state adds a lot of costs on. The state will add like jail and crime lab fees, surcharges, and so forth. So a $50 ticket turns into a total forfeiture of $124. That's
Okay.
especially true with this OWI, shorthand for operating while under the influence of an intoxicant. OWI shorthand, the $150 to $300 turns into a citation for $861. Now, when I say 150 or 300, the range usually is between $700 and $950. So you're kind of in the middle of that range. You understand that as well?
Yes.
Now, if you're convicted of this, you also 6 points will be assessed against your driver's license. In addition to that, there's some other penalties that you're required if you're convicted, or if you either plead no contest or guilty, or you're found guilty at a trial. Now, the other penalties you're facing besides the fine and the 6 points will be you would also have to attend an alcohol and drug assessment class. Okay. In addition to an OWI, your driver's license would be revoked between 6 and 9 months. Now, the penalty depends on a couple of factors. One is your blood alcohol content. Typically, if you're a 1.5 or lower, I have a 6-month driver's license revocation. If you're between a 1.5 and a 2 at 7, months. And if you're above a 0.2, it's 8. And if you're involved in an accident, sometimes I add an additional month onto that sentence. That's how I arrive at the 6 to 9 month driver's license revocation. Okay. Now, you are also faced with a citation called operating with a prohibited alcohol concentration. Now, that also carries a forfeiture of $861, 6 points, and you also have to attend an alcohol and drug assessment class, and your driver's license could get, you could have your driver's license suspended revoked between 6 and 9 months. Their penalties are the same for both. What happens on these is that I can find you guilty of both of them, but I only impose penalties on one. So in other words, the maximum driver's license revocation would be 6 to 9 months. It's not double that. Same thing with the fine. I don't double the 861. I find you guilty. I could find you guilty of both, but only impose penalties on one. The reason why the state legislature did that is that in order to prevail on an OWI, you also have to prove that not only were you were not operating a motor vehicle while under the influence, but also that you did not have a prohibited alcohol concentration. So they're two separate citations. Do you understand that?
Yes.
Okay. Now, and in addition to that, and is this the first time you've ever been cited for operating while under the influence?
Yes.
Okay.
I mean, they said yes because it's been 20 years.
Okay. The reason why is that if you've had a prior one, there's the additional penalties if you're above a 1.5 or greater. I also have to order an interlock ignition device be installed in all cars registered in your name. And I also require that when you're driving a vehicle for the next 12 months, that you have for a period of 12 months, that you have an IID installed. Now, the reason why that comes into play, if I've asked you had a prior, is that if you've had a prior, even more than 10 years ago, I must require that an IID device be installed in all vehicles registered in your name, and that you, when you drive for a period of 12 months, that you have an IID installed. There's nothing I can do about that. That's built into the laws as well. In addition, if I have to order an IID, I will have to surcharge you an additional $50. Okay, so IID if you have a prior, or if you're 1.5 or greater, or and a $50 surcharge. Okay, do you understand all that information that I spoke to you, or if you have any additional questions?
Yeah, I just was curious about when I spoke with the police officers. They said since my first OWI was 20 years ago, that this would be considered a first-time offense.
That would be a first time.
I'm not understanding that.
Right. This is considered a first because it's still civil. However, what happens is Wisconsin has a quirk that if you have an OWI and then longer than 10 years and you get a second OWI, even though that you've had a prior, that's still considered a first offense. Okay. However, under the IID law, if you've had a prior, I have to order that you have an interlock ignition device installed in all your vehicles.
Okay.
That's also the case if you're a 1.5 or higher.
Okay.
So again, and this is a plea. So any other questions besides what the officers told you that night?
No.
Okay. So I've kind of described the penalties and the driver's license revocation, IID, alcohol and drug assessment points and fine. I've described all 4 citations for you. You have any questions regarding any of the citations?
No.
Okay. Now I'm here just to take a plea. I can't dismiss a couple of the citations. I can't reach a plea agreement or a deal. If you want to do that, if you want to maybe have the others, if you basically want to talk to the prosecutor or have some of these cases possibly dismissed, I would suggest that you enter a not guilty plea and schedule this matter for a pretrial conference. Would you like me to review that?
No, Your Honor.
Okay. So if you can enter a guilty plea, and I would find you guilty, you can enter no contest plea, and that means you're not contesting the citation. You're basically no contest plea. You're not admitting guilt, but you don't want to contest the citations, and you want it to be done today. And if there's a factual basis, I find you guilty. Or you can enter a not guilty plea, and what I scheduled for instead of scheduling for a trial, I have you meet with the prosecutor to see if you can resolve it before a trial date. If you can, I will approve the settlement agreement. If not, then I would schedule it for a trial. You understand your options?
Yes.
Okay. Now's the time to take your plea. Your 3 plea options are guilty, no contest, or not guilty.
No contest, Your Honor.
Okay. You understand with no contest plea, if there's a factual basis in your police report, I'll find you guilty?
Yes.
All right. Excuse me. Let me read the police report. I want to make sure I have a factual basis for your plea.
Okay.
Okay, Ms. Vike, I've reviewed the police report. I do find a factual basis for your plea. I'll accept your no contest plea and find you guilty. Anything you'd like to say before I decide on a sentence?
No, I guess I'm more concerned about for my job because I work at Stoughton Hospital and I do have to take call. And I guess I'm trying to figure out how that's all going to work out for me.
Okay, I mean, would you like the opportunity to speak with an attorney before I decide to sentence you, or you can always withdraw your plea as well?
Well, maybe it wouldn't be a bad idea just to
Okay.
find out what my options are.
I will rescind your plea. When I said I found you guilty, I'll rescind that as well. What I'll do is I'll enter a not guilty plea on your behalf. We'll schedule this matter for a pretrial conference.
Okay.
And at the pretrial conference, what I will do is that make sure that you'll get a notice of when to appear. Mary, they're all doing it by Zoom, correct?
Telephone.
Okay. You'll get a chance to speak with the prosecutor over the phone, and then I would advise if you want to seek legal counsel to determine how this is going to affect your driver's license. That might not be a bad idea either.
Okay.
But make sure that you appear or call at the appropriate time, because if you don't appear or call, if you don't call, prosecutor tells me that you don't call, I'll find you default and I'll find you guilty of all these citations and impose those penalties then. So, but when you talk, I mean, the prosecutor might be inclined to say no IID, but if you enter an agreement, you'll have to enter an IID just because of the prior that you had, even though it's longer than 10 years ago. So
Okay.
Make sure that you appear. It's a chance to tell your side of the story. And then if it's successfully resolved, the prosecutor will report that. Otherwise, it'll be set for trial.
Yes, thank you.
Okay, we'll send that notice out to your address. If you have any further questions, there'll be a number for you to call on the form.
Okay, thank you, sir.
Okay, thank you, Ms. Mike.
Bye.
Yeah, you can go ahead and hang up. I always have to tell people to terminate the calls now. It's a new thing for me. So, all right, thank you.
Okay.
All right, the next person is Christopher Hansen. So I'll bring him in from the waiting room.
By phone only?
Yes.
Okay, you're Christopher Hansen? Mr. Hansen, you're on mute. I can't hear you right now.
You can't.
Oh, now I can.
Can you hear me now?
Yes,
Okay.
yes, I can hear you now. So this is Judge Matt Royalty. I'm the judge for Stoughton Municipal Court. We're here for initial appearances tonight. And you're Christopher Kenneth Hansen, is that correct?
Correct.
Okay, I have two citations for you. One for operating while under the influence and one for operating with a prohibited alcohol concentration. What I'm going to do,
Okay.
let me bring up your police reports because I have your address on that police report, so I can make sure that everything is correct.
Okay.
All right, it's going to pull up in just a second. Mr. Hansen, do I have your correct address on Olson Court in Stoughton?
Correct.
Okay, you received two citations. One is for operating while under the influence of an intoxicant. That's known as OWI, or first offense drunk driving. And the other is
Okay.
operating with the prohibited alcohol concentration. All right, do you understand each of these citations?
I've heard the OWI. I'm not sure about the prohibited alcohol content.
So basically you have two citations and they both have forfeitures of $861. So operating
I
under,
understand.
I'm sorry, go ahead.
I'm sorry, Your Honor. I understand now. They're kind of intertwined a little bit.
Right,
A little
exactly. So one is operating while under the influence of an intoxicant. That means that you are operating a motor vehicle with a substance that caused you to be impaired. Now, the prohibited alcohol concentration, that basically means for a first offense that you're above a 0.08 or higher under Wisconsin law.
Okay.
So there are two separate citations. So the fine, I can find you guilty on both, but I can only impose penalties on one. The reason why the legislature did that is they wanted to make it difficult to, you have to prove basically that there's two opportunities for the prosecutor to prove that you're above the prohibited alcohol concentration or above a 0.08, or that you were operating under the influence of an intoxicant.
Gotcha.
Okay, now the penalties are as follows. The forfeiture, it's listed forfeiture of $861. Now, there's a forfeiture range. The forfeiture range on an OWI is actually $150 to $300, but they add a $355 assessment cost to that citation. They also add various fees like jail and crime lab, surcharges, etc. So that's how a $150 forfeiture can wind up at $861. Now, the forfeiture range on this the actual forfeiture would range between about $705 and about $950. So you're kind of in the middle of that. I can go up or down depending on the circumstances. You understand that as well?
Yes, I do.
Okay. In addition, the penalties are you have additional penalties to this. It's also 6 points. If you're found guilty of either one, it's 6 points are assessed against your driver's license. If you're found guilty, you have to attend an alcohol and drug assessment class. And your driver's license will be, if you're found guilty, revoked between 6 and 9 months. Now, the way I determine the revocation period is as follows. I base it on your driving and your blood alcohol content. If you're a 1.5 or below, I usually will revoke you for 6 months. If you're between a 0.15 and a 0.2, it's 7. And if you're greater than a 2, it's 8 months. Now, if there's an accident involved, oftentimes I'll add 1 month to each of those levels. Do you understand that?
Okay.
So, all right. That's the driver's license revocation. Now, there's a couple additional penalties. Mr. Hansen, have you ever received an OWI before?
No, I have not.
Okay. So it's kind of odd, but if you had one prior to more than 10 years, it still counts as your first. But if this is the first time, then it helps my analysis. So if you had a prohibited alcohol concentration of 1.5 or greater, there's additional penalties. The state mandates that I order an interlock ignition device be installed in all cars registered in your name or any car that you drive for a period of 12 months if you have a prohibited alcohol concentration of 0.15 or higher. You understand that?
Okay.
So, do you know what an IID device is?
I have heard of them.
Basically,
I've never seen one, but I've never seen one, but I'm familiar with them.
Okay.
I'm not familiar, but
you've heard of them.
I know what it is.
Yeah.
I've heard of
So
them, yeah.
it's basically a tube that if you're above that level, you have to blow into it in order for the car to start. And it's a period that lasts for 12 months, and it's a $50 surcharge as well. And it's not one of those things that you can sit out and wait for 12 months. If you're found guilty of that, the first, what they call driver's license product, you get either an occupational license or a regular license. You would have, once you get a license, the 12-month period would then begin.
Okay.
All right, so I've discussed the IID, the surcharge. Now those penalties are the same for both the operating while under the influence and operating with a prohibited alcohol concentration. So you understand the nature. Do you have any questions regarding the possible fines and penalties?
No, I do not. I believe it was pretty clear, Your Honor.
Oh, great, thank you. All right, so we're here for a plea tonight. So let me explain each of the 3 pleas. The first plea option would be guilty. That means you're admitting your guilt. I'll review the police report. If there's factual basis, I'll find you guilty and impose the appropriate penalties. you can enter a no contest plea. And that means that you're not admitting guilt, but you don't want to proceed any further, and you want to resolve it today. And essentially, if there's a factual basis on the police report, I find you guilty then. The third option is a not guilty plea. That means that you don't believe that either that you committed these offenses or that the city couldn't prove their case. And if you enter a not guilty plea, what I do is I schedule this matter for a pretrial conference between you and the city attorney over the phone to see if you're able to resolve the citation. If you are, the agreement is submitted to me for my approval. If you cannot reach an agreement, then we set the matter for a trial.
Okay.
Do you understand your plea options?
Sort of, yeah. I'm not sure about the guilty and no contest where.
Okay. So basically, let me explain a no contest plea. Say if you're involved in a traffic accident, you're cited for running a stop sign and you hit somebody. If you're worried about that person suing you later for damages you caused for allegedly running a stop sign, what you would do then is enter a no contest plea, because then you're not admitting guilt. So if you're not admitting guilt, then that person can't use that guilty plea against you.
Okay.
That's essentially what it is. So guilty means I'm guilty, but no contest means, you know what, I don't want to admit my guilt, but I want to resolve this. I want to resolve everything tonight.
Well, then I suppose
Does that help?
I would enter. I'm sorry?
Does that explanation help?
Yeah, as much as it can, I suppose. I suppose I would enter a no contest plea.
Is that what you want to do? Because if you realize that if you enter a no contest plea, I'll review the police report, and if there's a factual basis, I'll find you guilty.
Well, I am guilty. I mean,
Okay.
it's
Well, you know what? If you're guilty, but how about this? You said no contest plea. Is that the plea that you would want to enter tonight?
If it resolves everything tonight, then yes.
Okay. All right. I will enter the no contest plea to the citation for operating while with a prohibited alcohol concentration, OWI. Mr. Hansen, let me review the police report. I want to make sure I have a factual basis for your plea.
Okay.
Just give me a minute.
Of course.
All right, Mr. Hansen, I have reviewed the police report. I do find a factual basis for your plea. I accept your no contest plea and find you guilty. Anything you'd like to say before I decide on a sentence?
No, thank you, Your Honor.
Okay. Now, I have reviewed the police report, Mr. Hansen. There's a couple things that concern me. One is that there was an accident here, and two was your blood alcohol content. It was rather high at 0.24. So because of these, I'm going to impose a 9-month driver's license revocation because that's provides standards of above a 0.2, and also because of the accident involved. I'm going to impose the face amount of the citation of $861. Your driver's license will be assessed 6 points. You'll be required to attend an alcohol and drug assessment class. In addition to that, since you're above a 0.15, I must also order an interlock ignition device be installed in all vehicles registered in your name. And I must order that you drive with an IID in all vehicles for a period of 12 months. And I'm going to I have to do a surcharge of $50. So the total amount owing will be $911. How much time do you need to pay for the $911?
I could pay it right now.
Oh, okay. I'll grant you 60 days, but if you'll get the notice, if you can pay it all right now, right immediately, then just send it and make sure that you send it in once you get the notice.
Okay, so all this will come in as a notice in writing. I'm just jotting down everything, and
Yep.
it's tough. I'm sorry.
Okay, and we'll also send you a form that was called you have to sign up for an assessment. So make sure that you sign that and get it. And Mary, you require him to send it back to us, correct?
No, that goes,
Oh, okay.
it's handled with the DOT.
Okay, so you'll get a form for an assessment and about how to sign up for assessment. Make sure that you call them right away as well.
Okay. I will
Now
do
you'll be
that.
getting some other information. We'll send a whole court packet. If you don't understand any of that information, just let us know.
Oh, okay. Thank you, Your Honor.
Now, Mr. Hansen, I've got to ask, what did you learn?
A very valuable lesson that one small, stupid error can change a lot of lives and a lot of the future. And it's something that I will never do again. I can blame 2020, I can blame COVID, but in the end, I have to blame myself. And it's awakening.
Okay, good. That's a good answer. That's one of the reasons we always look for people to accept responsibility, and it appears that you have. Just be careful though, because if you do, for whatever reason, get cited or charged with an OWI second, there is mandatory jail time with a second offense, and the penalties grow more severe with each offense.
Oh, okay. Yeah, no, that is a deterrent enough. Actually, this is a deterrent enough.
Okay, good. Well, we'll send you the documents. Any questions, there'll be a number for you to call.
Okay.
That will take care of it for this evening, unless you have any questions.
No, I don't, Your Honor.
Okay.
Thank you for. Unfortunately, we have to do this over the phone right now, but we're all adjusting.
Right, we are. That's a good statement. So, okay, since that will take care of it this evening, you can go ahead and hang up.
Okay, thank you.
All right, thank you. We have a 6 o'clock hearing, is that right?
Right, yeah. Do you want to do the defaults?
Yeah, let me do the defaults, although, let me go get a glass of water.
Okay.
When I talk like this and my throat gets dry, so. All
I
right,
have one right here.
all right. Give me a minute, I'll be right back in a few
Okay.
seconds. All right, thank you, Mary.
Mhm.
All right, so let me get my pen. Let's go through these. I think I've got the most updated play sheet. If I have another, if I miss one, just let me know.
I will.
All right, Ramiro Aguilar, it's a bond forfeiture. Slide this one over here. Actually, I think it's. Andrea Allen is a default judgment. Carissa Alt is a default judgment. Ruben Alvarado is a bond forfeiture. Calvin Anderson is a bond forfeiture. Joseph Ashbrook is a bond forfeiture. Amiro Ba is a default judgment. Nicole Bauman is a default judgment. Kaylee Benke is a default judgment. Julia Bell is a default judgment.
He actually called this afternoon and wanted to enter a no contest plea. So,
Oh, that's not on either one of these I have.
no, she called just before court.
She wanted to do what?
No contest plea.
Oh, any reason why?
No, she's, I think, more interested in point reduction, but I said she would need to send a plea sheet, and she said, just enter no contest for me.
Okay. I'll hold it open if she ever wants to look at the fines again.
Okay.
So, and failure to stop at a stop sign, she'll probably get a notice to complete that class as well. So. Jace Billig, a default judgment. Reese Bittrick is a default judgment. Virginia Blebo is a default judgment. Ryan Bowman is a default judgment on both citations. Tyler Bozaki is a bond forfeiture. Sarah Castillo is a default judgment. Melanie Chamberlain is a no contest plea. Is there any plea sheet?
No explanation. Some people, I think, are confused and they just send no contest just
Okay.
to get it on the record. So.
Well, treat it as a no contest plea for that.
Okay.
Edulette Marcetta Clark is a default judgment. Marcus Clark is a no contest plea. I'll accept the no contest plea and find Marcus Clark guilty. Let's see, John Cobo is a default judgment. Channel Coleman is a default judgment of both citations. Don Copus is a bond forfeiture. Lloyd Cosme is a default judgment. Elena Delzer is a bond forfeiture. Bradley Dillman is a no contest plea, accept the no contest plea and find Mr. Dillman guilty. Kevin Dustin is a default judgment on all three citations. Next is a Tyler Engelman, that is a bond forfeiture. Next is Michael Foss, that's a default judgment. Michael Fredericks is a bond forfeiture. Frank Frio is a plea sheet. Let me take a look. No contest. Hang on, it's upside down.
Oh.
Reduction of the fine. All right. We take a look at the forfeiture since he asked. $376. Can you go? Is there a forfeit? I don't have my bond book in front of me. You know what? I'll take it down to $250.
Check what that would be. That's what it is. 250 is what is right now.
I have it at 376.
That's the total, but the bond is
Oh,
250. So
oh,
your total, you're saying total 250?
yeah, I think it's a $125 bond, $250.
All right.
Verify that. Is that correct?
I will. I don't have my bond book here right now either.
Okay. Okay. Yeah, basically 125 plus cost, I believe, is $250.
Sorry, I got it now.
Okay.
$150. Sorry. I'll verify that, but we'll put it down that you want it to be 250 for the total. I'll
Right.
contact
Well,
you.
actually, whatever. What is 130 plus cost? Do you have the back of the bond book?
Let me.
Oh,
Sorry, I have better luck with this one. So. This has everything. 250. Oh, sure. The fine for $250 total would be $150 for the fine.
that's what we'll do. 150 plus cost will be 250 total. All right.
Okay.
Thank you. I'll remember that for next time.
All right.
Okay. And next would be Mary Golden. It's a bond forfeiture. Next would be Hallie Hack is a default judgment on both citations. James Hammis is a default judgment. We took care of Mr. Hansen already. Next is Lisa Harride is a bond forfeiture. Robert Harride is a default judgment. Eleanor Hills is a default judgment. Damon Hoffman is a default judgment. Kevin Hudson is a bond forfeiture. Victoria Hutchinson is a guilty plea, accept a guilty plea and find the defendant guilty. Next is Micolette Jarvis is a default judgment on all three citations. Next is Jada Jones. That's a default judgment. Next is Kateri Kraus is a default judgment. Brandon Lokarek is a bond forfeiture on both. Let's see, bond forfeiture on the seatbelt. Let me take a look at the plea sheet. No contest. All right. For a creative no contest plea. $100. What's $60 plus cost? Do you know that?
$136.60.
Yep, that's what we're reducing to $60 plus cost.
Okay.
Accept the no contest plea and find him guilty and post $60 plus cost.
Okay.
Next is Braylai Luxinger is a default judgment on both citations. Thomas Marsh is a bond forfeiture. Robert Maurer is a default judgment. All right, Miss Micheline McCormick. Okay, the no contest plea just kind of provides what happens. So I'll accept the no contest plea and find the guilty. find the defendant guilty, not change any of the points or cite or the forfeiture
Okay.
amounts. Tommy McLean is a default judgment. Zaira Mendoza is a default judgment on all 3 citations. Tyler Miller is a default judgment on both citations. Danielle Mitchell is a default judgment on all 3 citations. For the retail theft, I'll hold restitution for now. Well, hang on. Let me take a look at this. Oh, shoot. It's a long report. It's going to take me a while to get through it.
I haven't been keeping track of these because you had said while we're doing this, you weren't doing the restitutions. So.
Yeah, I think that we'll hold this one open too, if they ever want to file it
Okay.
again. Okay, so no restitution. Well, we'll hold, I won't order it tonight, but we'll hold open the question if anybody wants to file. Next would be Dion Mitchell is a default judgment. Roxanne Moat is a default judgment. Tyler Marshall is a default judgment. Michael O'Neill is a default judgment. Chad Osman is the default judgment on both citations. Ricardo Antonio Pagan Rivera is a default judgment. Drew Poswold is a bond forfeiture. Ulysses Rivera Resendiz is a default judgment on both citations. Charles Ree is a bond forfeiture. Eric Reinerson on the motion of the city court will dismiss the citation. Elvin Rivera Martinez is a default judgment. Matthew Roach is a default judgment. Rebecca Roach is a default judgment. Daniel Rose is a default judgment on both citations. Trevor Michael Schmidt is a default judgment on both citations. Again, I'll hold open the issue of restitution if anybody ever files. Navong Pafan So is a bond forfeiture. Mary Steele is a bond forfeiture. Randy Roller Stiller is a default judgment. Courtney Swenson is a default judgment. Peter Tenjum is a bond forfeiture. Sean Thorpe is a default judgment. Sheila Trentini is a no contest plea sheet.
That one is going to be a little hard to read, so let me know if you have trouble with
I'm
that.
sure I will. All right. So I judge all people's handwritings based upon my own.
That it was actually faxed to us,
Okay.
and through that transmission, it got a little.
Well, the reason why I say that is that this is actually this is legible. It's just the you're right. It's a fax. It's a difficult
Yeah.
copy. Okay. So I've reviewed the plea sheet. It basically it's an apologetic leniency. I won't order a restitution, but we'll just hold the face amount of the citation $187.
Okay.
I don't see a reason to deviate from that.
Okay.
All right. Karen Veek, not guilty plea. Stacy Vitens is a default judgment. Nicole Volmer is a default judgment on both citations. Blake Wake is a default judgment. Brendan Wiesner is a default judgment. Austin West is a default judgment. Andrew Wheeler is a default judgment. And Daniel Winters is a default judgment. Okay, we have 6 o'clock.
Right.
Is she in the waiting room yet?
Nope.
Okay.
No. Your email, I copied and scanned, and it's in that file for under her last name, Heather Reed.
I printed out a copy for myself.
Oh, okay. All right.
Okay. You know what, Mary? I'm going to take a 10-minute recess. I'll come back in about 10 minutes.
Okay.
All right. Court's adjourned for approximately until 6 o'clock. Thank you, Mary.
All right. Thank you.
That's going to take me a while to open up and close all these. So, okay. I'm going to leave the meeting. I'll see you in 10 minutes.
Okay. Hi, Amy.
Hi there.
How are you?
I'm good. How are you doing?
Good, considering.
Yeah.
Oh,
I've spent a lot of my day interpreting the new order.
oh, I didn't even hear about this. Oh,
Yeah,
no.
new Dane County order. So it
Oh.
affects some of my family cases. So
Oh,
been the
oh,
discussion of the day.
okay.
Mhm.
Wow. Oh,
Yeah.
boy. Yeah, it's just crazy. It's not getting any better, it seems.
Yeah.
Uh,
And I am just sending the pre-trials over to you now.
okay, well,
I thought I had emailed them already and I had not. That's how this day is going.
oh, yes. That's how this year is going.
Yeah, right. Okay.
Matt just took a quick break. He should be here in a minute. The defendant has not arrived yet. And I don't know if I gave much explanation. This is the one she had requested to be reopened 2 weeks ago, or a month ago. And she has an occupational license and received this violation while having an occupational. So Matt did a little research and he's coming back with his response to
Oh.
her. So,
I do remember that. Yep.
yeah.
Hi, Ms. Collins O'Hara. How are you?
I'm good. How are you doing?
Good.
The defendant has not appeared yet.
Okay. So the defendant filed a motion to reopen because she received an occupational license, didn't have anything regarding moving violation, right?
Right. And you granted the request to reopen. It was just then she came up with this question. The only reason she wanted to talk to the city attorney is because of having the occupational license.
Okay.
So,
Well, how about this? While I granted the motion to reopen, if she wants to, we can discuss, and if we'll schedule her for a pre-trial conference and you can review it, Ms. Collins O'Hara, with it. I actually did some research, but I'm curious to see if you came up with a different answer than I did. So, okay.
Oh.
I'll grant the motion to reopen and then we'll just schedule it for a pre-trial conference then.
okay.
Sounds good.
All right,
That's it.
anything else?
Nope.
Okay, thanks, everybody. I should have taken care of before this, but I thought that she was gonna appear and explain things, so we'll
Yeah.
leave it at that.
Okay,
Okay,
Thank
thanks,
you.
Mary. I will see everybody in a couple weeks.
okay.
Good. Thank
Bye-bye.
you.
All right,
Thank
bye-bye.